I get a lot of clients asking what Aguilera Law Center stands for, who do we help, and what do we do? And just to answer all of those questions, I wanted to state that Aguilera Law Center is here to help people, families, individuals, the community, and help them figure out a solution out of whatever problem they're in. What is an uncontested case? And what is a contested case? Because many attorneys differentiate the pricing of a case based on whether your case is uncontested or contested. Uncontested means that you are in agreement with your spouse in a divorce. It means that we're not going to go to court. We are not going to be attending any hearings. You, as the client coming in, you have already discussed the substantial issues in the case with your spouse. You're in agreement with any areas that may come up, such as if there's a child, that would mean time sharing, a parenting plan. So you're all on the same page as to where is the child going to be, on what days, on holidays, and you pretty much have an understanding and agreement on what the marital agreement is going to contain. When I have a client that says they have an uncontested case, we'll take it as an uncontested case, unless in talking with you or with my client, I will get facts from your case and decide, okay, well, this is not uncontested anymore. I think your case is contested, and I will tell you the reasons why. Let's say you guys have not discussed time sharing and you want a certain schedule, and let's say your spouse wants another schedule. That is something that you both are going to come to and you're going to have a disagreement about. That is now considered contested. So there are times where clients come in not knowing really what uncontested means. And many times, particularly in our office, we will consider uncontested cases and price them as flat fees. But if it turns into a contested case midway before finalizing the marital agreement, I will tell my client, this is now a contested case. We are in disagreement. And then specifically, a domestic violence restraining order, also called an injunction, is something that you would have to go to court, go to the domestic violence centers at the courthouse. There are local courthouses, and if you Google the locations near you, you should have an address, know what time you can go, and you can rush over there, apply for what's called a petition for an injunction. And if it's specifically for someone who lives with you, then you need to say that it's a domestic violence issue. And when you go to the courthouse, you have to let the case manager know, whoever's helping you at the courthouse to apply, let them know what happened in the most recent incident against this person who was the aggressor. You need to go there prepared with the information of how they look, where are they located, where are they residing, and if you don't know, that's fine too, but make sure that you go so that you can be protected. And the restraining order, if it's granted, will provide you with that extra protection so that the aggressor cannot come near where you live or where you work, or wherever you go outside of your home, and they cannot step any closer than 500 feet. The closest they can get is 500 feet from you. So some of the questions that you need to ask yourself when you're asking, should I go get an injunction? Should I apply for a restraining order? Ask yourself, are you in immediate danger in becoming a victim of domestic violence? And the key words are immediate danger. So you have to feel like the danger is about to occur. It's immediate. And so that's something important. And the judge at the hearing or while they're looking at your petition will look at many factors, such as the history between you and the aggressor. Has he threatened you before? What happened most recently? When did it happen? So all of the specific information that you can provide helps. So the history, any prior incidents, any of that should go into the petition when you apply for the restraining order. At the Aguilera Law Center, We do file petitions on behalf of victims. However, we always recommend that if it's a danger and it's immediate, you should go to the courthouse after calling the police. Go to the courthouse and apply for the petition. When you have a deposition is usually in a court case requirement, and it's part of what's called a discovery process. And when one party, which is whether it's the plaintiff or the defendant, wants to get more information from a specific person that's relevant to the case, let's say a witness or an actual party, which means you, if you are being sued or if you're the one that brought on the suit, whoever has the evidence or information that's relevant to the case, the parties can actually subpoena you to appear to a deposition. So let's say you get a subpoena for a deposition, and that means that you are required to attend. If you are unable to attend the deposition, then as soon as you get that subpoena, you need to let your attorney know, or let the attorney that sent you that subpoena, let them know that you need to reschedule it. Because if you do not do that and you do not appear at the deposition, there can be consequences. You can be held in contempt, you can be fined, you can be sanctioned by the court. And so you definitely want to be very careful. When you get a subpoena for a deposition, you need to either attend the deposition or let them know that you're unable to attend. You're going to be asked a bunch of questions from the attorney that sent you the subpoena. You're also going to be asked questions by the other attorney who is representing the other party. And the reason for that is because the attorneys want to make sure that they get all of the information that's relevant to help them in their case. And if you are, let's say, a witness and you are afraid of what you're going to say and you want to be prepared, then you definitely want to get your own attorney to help you decide what information can I say and what information is privileged. So a deposition, you do have to attend, like I said, and a deposition is going to be recorded by a court reporter. And nowadays, when you're in the during the pandemic, it's all virtual. So you actually have a court reporter via Zoom taking a record of everything that you're saying. So a deposition is a very important part of the process in a court case, and you need to take it seriously. So you need to be prepared. And if you're not, and you're worried about it, then you need to talk to an attorney.